Uh, I think that now it's time to start. Uh, we are good to go. Right, Ryan?
Sure, sir. We need to start.
Okay, great, great. With this, I would like to welcome everyone for today's session. You might be informed that today's session is on the right to freedom of expression, opinion, assembly, and association. So, today we will be discussing the fundamental human rights to express ourselves and share some of our opinions, and then all together come to a consensus and with other forms of associations and peaceful assembly where as far as freedom of speech and expression or the opinion and assembly is concerned, I think it is very essential to build an inclusive and democratic societies where actually we all individuals can live freely and express our ideas, beliefs, in opinion without any fear of maybe censorship or other reappraisals. So basically, in today's session, we are going to explore the scope, of this right and how it is protected under not only national but then also international law if possible. And there are other ways where we'll find out that how these rights have been violated at different parts of the world. So we are going to deal about the aspect of it, and then we will also try to maybe the speaker will maybe discuss about the how the individuals in the group can actually exercise their rights responsibly and constructively and in the ways respect the rights of others as well. Mm. So I personally believe that throughout the session you all will keep you encouraged so that even you at the end of the session can share some of your thoughts experiences, and maybe we can take up the questions at the last when of the session when it's over. I think that since today's session will be taken by one of our speakers to whom I would like to introduce that her name is Dakshita Bajpayee. She is one of the highly accomplished individual who has a domain expert in the field of law. Ms. Bajpayee actually holds BLLB from a prestigious Nalsar University of Hyderabad. The law students must be knowing that. And she has completed her Master of Laws from Gujarat National Law University. And to a matter of fact, as far as research is concerned, she has a good hands over it as she has qualified NET and as well as JRF. So she has a hold over the research methodology. So without maybe delaying to it, just to as you must also know that she is also a junior research consultant at National Human Rights Commission, where she has been utilizing her expertise to make n number of contributions, significant contribution for that matter, in the organization as far as my knowledge is concerned. So I would like you all to maybe join by extending a warm welcome to Ms. Dakshita Bajpayee. She is going to take or the lead the session and give you a very nice parameter of how freedom of speech and expression and association and assembly is to be taken into consideration. She has her own perception, and at the end of the day, or maybe sorry, at the end of the session, I think we'll take up the questions accordingly. So over to you, Dakshita. Please take forward this particular session. Thank you.
Okay, hi Pranav, and good evening to everyone. First of all, let me thank you, Pranav, for giving me such a kind introduction. I'm really humbled. And for rest of you, I'm really glad to be here. Now, as Pranav has already mentioned, the agenda for today's session is right to freedom of expression, opinion, assembly, and association. But before we begin with this, let's just go back to the basics. And I want all of you to think for a moment about what exactly does freedom, fundamental rights mean to you. I would really want to hear from you guys as to what does fundamental right means to you in very basic terms. What is your understanding of fundamental rights? So can we have a few responses? You may please unmute and speak. Anyone? Like Please be assured this is a free platform, and as Pranav said, this is a mode wherein we will get to exchange a lot of ideas and learn, because uh, all of us equally are learners here. No one's above anyone. So yeah, can we have people? Okay, okay. I have Anas. Anas, would you like to speak something?
Hello, ma'am.
Hi. Yeah.
Ma'am, for the question you asked, I believe that these are the basic human rights which are given in the Constitution,
Right.
fundamental.
Okay. Okay.
They
Thank
also
you.
come with reasonable restrictions.
Right. That's a very important point that you have made on us. Anything
Thank
else
you,
that you
ma'am.
want to add to this? Or we go
No,
to the
ma'am.
next?
Thank you.
Okay, thank you, Anas. Now we have Supraja. Supraja, would you like to say something on this?
Yes, sir.
Yes,
Yes, ma'am.
ma'am. A very good evening, ma'am.
Yeah, yeah.
Like according to me, like a fundamental right is means like the man by birth have certain rights, which are universal, and he could not be deprived of those rights, and it is termed as like fundamental rights according to the law.
All right. All right. Thank you, Supraja. You bring a very important dimension to the very concept of fundamental rights, which is natural rights. Natural rights are the rights which a person is naturally born with. So, fundamental rights, as Anas also very rightly pointed out, are the basic rights. Okay, Fazal has something to say. Fazal, please. Yeah.
Yes, ma'am.
I'm
All the
sorry,
right
Fazal, your
which
voice is
guaranteed by the
breaking.
state, right to live, right to education, and right to self-determination.
Right,
Ma'am, now
correctly.
it's
So,
clear.
see, Fazal, right,
Hello.
right. Hello, yeah, Fazal, please go on.
Ma'am, all those fundamental right which guaranteed by the state, right to live, right to education, and right to self-determination, all those basic fundamental right which guaranteed by the state.
Right. Fazal has very rightly identified. Fazal has, in fact, gone one step ahead and has identified what exactly are the fundamental rights. So, as all of you have rightly pointed out, and I'm very impressed, that fundamental rights are those certain basic rights that ought to be guaranteed to every individual so as to, enjoy the very basic liberties of human existence. Now, as you all might be aware, that fundamental rights. Okay, Rukshat has raised a hand. Yes, Rukshat, you want to say something?
Yes, ma'am.
Yeah.
Ma'am, I would like to add that along with having these basic rights, it also provides us few that causality that if someone violates those, then what are the penalties that can be in charge? And we also have the writs of habeas corpus and several other sections in the IPC, and like if somebody like violates our rights, then what can the actions we can take about? So it not only guarantees us the right, it also provides us security somewhere.
Right. Rukshat, you're very right when you say that fundamental rights are not absolute. They are restricted, and they have to be restricted so that everyone can safely and securely exercise those rights. So, okay, so as I was mentioning, that fundamental part 3 of the Constitution of India contains these fundamental rights, and the very idea of fundamental rights was borrowed from the Constitution of the United States. Now, if we come specifically to Article 19, it's important to understand that fundamental rights, as contained under Part 3, while some of the rights are exclusively enjoyed by the citizens of the country, some rights are so fundamental and so integral that they are available to be enjoyed by every person, every individual has the right to enjoy. For instance, Article 21, which includes right to life and liberty, that is enjoyed by everyone. However, if you look at the text of Article 19, I would really request all of you to open the text of Article 19 in your devices or wherever. It states that all citizens shall have the right. So, the first thing that we need to be aware of is that Article 19 is restricted only to the citizens of India. So, for the purposes of today's session, we are particularly concerned with Article 19, subclause 1, Part A, B, and C. which include the right to freedom of speech and expression, to assemble peacefully and without arms, and to form associations and unions, and also subclause 2, 3, and 4 that contain the restrictions pertaining to those fundamental rights, as Rukshat had mentioned. All right. So, I'm sorry. If we go back to the Constitution Assembly debates pertaining to Article 19. So, Article 19 was Article 13 of the draft Constitution of India that was debated on 1st and 2nd December 1948. The main point of contention pertaining to the text of Article 19 pertained to the restrictions that had to be put on fundamental rights. So it's important for all of us to understand that no right can be absolute. Now, why do you think that no right can be absolute and there has to be certain restrictions? Would you like to answer this? Why do you think fundamental rights cannot be absolute and there have to be like certain inherent restrictions? Yeah, Anas has raised his hand. Yes, Anas.
Ma'am, so when we are given rights, there are also certain duties that one must adhere to and not actually abuse that right which is given to them. So, in order to protect the national interest, sovereignty, foreign relationship with other states, and some other criterias, we need to respect each others and use this right very carefully.
Right. Anas, you're very right when you say that there have to be certain restrictions in the interest of sovereignty or integrity of the state. We also have Benita raising her hand. Yes, Benita?
Ma'am, restrictions are provided because, like, to ensure that while exercising our right, we don't violate or like abuse the other people's right. Because if everyone individual starts exercising their right absolutely, then there will be a chaotic situation in a society.
Benita, you are bang on when you say this that exercising every right absolutely will lead to chaos. Now, I would really want to share this one quote by the famous United States Supreme Court Judge Oliver Wendell Holmes. He said that your right to swing your arm ends just where the other man's nose begins. This means while you do have a right to swing your arms, but that right does not extend to breaking someone else's nose. So, in other words, your right ends the moment someone else's freedom begins. To freedom which is given under particularly Article 19. However, you have to exercise those freedoms in a responsible manner. Only then can we ensure that everyone gets to enjoy those freedoms.
There, she ended her question, but then yeah, it was left.
Okay, okay, all right, all right. So yeah, so this is why we it's important to understand while we are looking at the various rights given under Article 19 as to what are the restrictions on that on those rights, and which is why subclauses 2, 3, and 4 of Article 19 become really important. Now, another very important point which I want to flag, and it's very interesting that when we talk about the importance of these restrictions are important to put a limit on the power of the legislature to restrict these freedoms. Now, what happens is if the state or the government decides to restrict the freedoms, it can only restrict the freedoms when it comes under any of the restrictions mentioned under subclauses 2, 3, or 4. I hope I'm able to make my point very clear, because this is one of the very important points and this is not adequately highlighted. It is right that, rights have to be restricted for all of us to enjoy these rights equally. At the same time, putting restriction on these rights serves another important purpose, that is restricting the arbitrary use of the power of the state to restrict those rights, because as you know, it is ultimately for the state to put restrictions on our right to freedom of speech, to form associations or unions. However, the state also cannot go overboard or beyond the restrictions which are expressly mentioned under subclauses 2, 3, and 4. Now, while we're discussing the restrictions, it's very important, if you look at the text of Article 19, subclause 2, subclause 3, and 4, they talk about the word restriction has been classified by the term reasonable. So, not every restriction on the freedom can be valid. Only those restrictions that are reasonable are valid. Now, what does the word reasonable mean? So, since the word reasonable has not been interpreted anywhere, and this is where the judiciary has stepped in, the Supreme Court has given its own interpretation to the word reasonable. And reasonable, since there is no definitive test, there cannot be any definitive test, because reasonable is a very subjective idea. What was reasonable 10 years ago might not be reasonable today, and vice versa. I'll give you one very basic example. Since we are living in the era of COVID or post COVID, um, there were during the COVID times, the state did put certain restrictions on the movement of the people. Now you might say that otherwise the state does not have any right to restrict the movement of the individual, since every citizen has the right to move freely throughout the territory of India. However, when if you look at it in the context of COVID, that very restriction on the movement of people becomes reasonable. So I hope this explains the idea that any restriction which is reasonable can only be allowed by the state to be put on the freedom of rights. Further, the court, if you look at various judgments pertaining to wherein the court has interpreted the word reasonable restriction, the court looks at certain factors. Now, what are these factors? The duration and extent of the restriction. If, let's say, the restriction is for a short duration of time, it might be considered as a reasonable restriction. But let's say if the court says that because there's COVID, no person will be allowed to move for next 10 years, this becomes unreasonable, because this is completely what do I say, unreasonable to restrict the movement of individuals for 10 long years at one stretch. So the extent and duration of the restriction becomes one factor. Then the second factor is the circumstances under which and the manner in which that restriction has been imposed. So for instance, even again looking at the example of COVID, because this is like something which all of us can relate to because we've gone through this, saying that okay, you cannot move during certain periods of time, or you should not move in crowded areas, seems a reasonable restriction. But let's say if the government decides to restrict the movement of every individual to their homes, you're not allowed to step out even to like get essential groceries, would that still be a reasonable restriction, as was the case in China? China is an authoritarian state, which is why they were able to pull it off very well. But if India decides to impose a similar restriction, that will not be a valid restriction, because it is not reasonable under Article 19, subclauses 4. It will fail the test of reasonableness. So these are the certain factors which the courts have considered while determining what could be a reasonable restriction. Again, just to repeat, there cannot be and there ought not to be a definitive test of reasonableness, because the contours of reasonableness would differ pertaining to with respect to the context in which we are talking about those restrictions. Okay, so after this, we quickly, one after the other, we look at the three rights which have to be discussed for today's session. I'm sorry, like, I think I took way more time in setting the ground. Anyways, we quickly come to the first freedom, which is freedom of speech and expression. Now, this is very interesting, and this is one of the most debated and contentious freedoms of our current times. Now, what does freedom of speech and expression means? What are if you look at the various Supreme Court judgments pertaining to freedom of speech and expression, you will realize that the court has given it an expansive meaning. There have been a lot of freedoms which are implied in speech and expression, even though they are not expressly stated. It is important, before we understand what speech and expression is, it is important to understand the importance of freedom to speech and expression. Interestingly, if you look at the text of Article 19 very closely, it states that all citizens shall have the right to a freedom of speech and expression. You understand, please understand the importance of the phrase freedom there. No other sub clause, sub part of clause 1 states freedom of, while speech and expression states right to freedom of speech and expression. As against, let's say, subclause B, it states right to assemble peacefully. This means you just do not have the right to speech and expression, you have also the freedom, which is the right to freedom. Please understand there's a difference. I hope I'm able to express myself, and I'm not confusing you guys here. This is just to show that how important is the right to freedom of speech and expression, and it is rightly called as the mother of all liberties. Can any one of you, justify? Uh, thank you, Pranav, for displaying the text of Article 19. Much needed. Why do you think right to freedom of speech and expression is called the mother of all other liberties? Why so? Anyone? Just take a guess.
Ma'am,
Yeah.
can I?
Yes,
Ma'am,
Ruksha.
ma'am, because our country is a democratic, and here we are free to criticize the government and their policies, and this comes from the very right to freedom of speech and expression, where we can seek information on ideas and thoughts, and also we can share those.
Right, you're very right, Ruksha. Just to rephrase what you have said, it is called the mother of all other liberties because this is the very means of protecting other liberties. Through speech and expression, only can you guarantee other liberties. So, if I, for instance, I do not have the right or the freedom of speech and expression, if my other rights are getting violated, I will not have any means to express that violation, and if I cannot express that violation, I will not be able to seek redressal, which is why right to freedom of speech and expression is known as the mother of all liberties. And without freedom of speech and expression, it's in fact it comes at the top of the hierarchy. All other rights automatically become redundant, because the moment any other right is violated, without you having the right to freedom of speech and expression, you won't be able to express the violation of that right, or, and for that matter, seek redressal for that. Now, if you talk about the scope or the true extent of freedom of speech and expression, so it includes within it the idea of propagation and interchange of ideas, dissemination of information, which also includes sharing your own opinion with others. Okay, Rukshat, you have raised your hand. You want to say something?
Ma'am, I have a question
Yeah,
actually on this.
yeah,
Ma'am,
yeah.
today we can see a lot of UAPA being charged on the people who are expressing themselves. So, isn't it a violation of this fundamental right of expressing and like this?
It is, but as I mentioned, this right is not absolute. There are restrictions. So even if you look at it, UAPA, the state is including UAPA under the restrictions mentioned in Article 2, because it says that any unlawful activity inherently harms the interests of sovereignty and integrity of the country or the security of the state, and which is why UAPA is only justified. If you look at the justification which the state government is giving to impose UAPA, it is mostly it is pertaining to the interests of sovereignty or integrity of the country, and which is why it is being justified. I hope I was able to address your question, or do you have
Yes.
any more clarifications to seek, Rukshat?
No, ma'am. Thank you.
Okay, okay. So now we quickly move to after this, so yeah, where were we? We were at the right to freedom of speech and expression. If you look at the judgments now, I do not have the time to discuss each and every judgment in detail, which is why I will be sharing the gist. If you look at the judgments, the courts have very rightly given a very broad connotation to the idea of free speech and expression. Some of the contours of free speech and expression pertain to the right to choose one's personal appearance or dress. So, court recognizes this as a right of expressing your own self through your clothes, you expressing your identity through your clothes. Now, this could be something very basic, but if you look at it from the point of view of the people belonging to the LGBTQI community, it is a very strong right, because they have a very particular way of dressing themselves, and they express their identity through their clothes. So it has very important ramifications for them. Now, Another important facet of right to speak is right not to speak, right to silence. This means that just because you have a right to speak also means that you have a right not to speak and right to stay silent. Then it also includes the right to receive information, because if you receive information, only then will you be able to disseminate that information or express your views on that information. So right to receive information has also been considered a part of freedom of speech and expression under article 191A. Then you also have freedom of press. This is a very interesting area again, because as against the US Constitution, wherein right to freedom of press is expressly recognized as a fundamental right, in the Indian Constitution, we do not have any express mention of the freedom of press. However, that has been impliedly considered as a part of a free right to freedom of speech and expression by the Supreme Court in various judgments. Because, and this is the court has mostly relied on the importance of press is generally considered as the fourth pillar of democracy. It's important, the press, by reporting whatever is happening across the country, makes individuals and citizens aware of what their rights are and how their rights are being violated across different domains. So which is why freedom of press becomes an important part. Another important and equally contentious aspect of freedom of speech and expression is the right to engage in demonstration, picketing, or dharnas or strike. Now, strike is one contentious issue wherein the courts do not have clarity if you look at the judicial judgments. However, if you look at picketing or demonstration, what is picketing or demonstration? It's called dharna in Hindi. It's about people peacefully gathering at a place and raising their demands or whatever complaints they have against the authority concerned. So picketing, peaceful picketing and demonstration has been recognized as an important facet of freedom of speech and expression. However, as far as strikes or bunds are concerned, the Supreme Court has mostly given a very contentious judgment wherein there are certain decisions which say that strikes are illegal, and there are other decisions which have legalized a strike as a medium of expressing yourself. Another important aspect of freedom of speech and expression is right to travel abroad. I'm sure, like, we are aware of the Menka Gandhi case, wherein the court said that right to travel abroad, though it comes under Article 21, the court also discussed article its importance in upholding Article 191A, because once you go abroad, you will be able to express your ideas. However, if you are stopped from going abroad, your right to free speech and expression might be infringed there. Then there are particular cases pertaining to tapping of telephone calls. Now, since when you engage in a telephonic conversation with anyone, this is a medium of you exercising your right of freedom of speech and expression. However, phone tapping violates that right, which is why the courts have uniformly considered phone tapping as illegal and a violation of the rights. Yes, Anas, you have a question.
Ma'am, in respect to phone tapping, wouldn't it be violative of right to privacy instead of right to freedom of speech and
It's
expression?
it's violative of both. You're very right when you say that it does violate a right to privacy at the same time, because you need to understand. As I said, if I am engaging in a telephonic conversation, I am somewhere exercising my right to freedom of speech and expression as well, because I will be expressing my ideas, my opinions through that telephonic call. But if that is getting disturbed by phone tapping, it does violate. Though you're right, it mostly is more when we talk about the violation of rights vis-a-vis phone tapping, it's more to do with right to privacy, but at the same time it also does violate the right to freedom of speech and expression. I hope I've made myself clear.
Ma'am,
Yeah.
can I ask one more question?
Yeah, sure.
Ma'am, how does one find balance? Because if we look at it, some statements are totally goes under sedation when one is criticizing government. But some of these statements are also, if some those who enjoy privileges like parliamentarians, it is very fine for them to say anything they want. So how does like saying against ruling party is same as sedation, or saying against government could be the one abusing the right to freedom of speech and expression? So what is this
Uh,
balance?
I'm sorry, I did not get your last part clear. Can you please go over that again? Saying against the government, I didn't get that part
So
clear.
Ma'am, for example, if one says against something against the ruling party as such, not against the government,
Mhm.
so that is also at some level is considered sedition. So what is the balance here? What is considered as state? What is this difference that we can strike a balance between?
See, you need to understand. You have asked a very pertinent question here on us. First of all, when we talk about now, you have your question has multiple aspects. I will be touching on them one after the other. So, first, you raise this question pertaining to the exercise of parliamentary privileges vis-a-vis sedition. So, if you read the law surrounding parliamentary privileges, parliamentary privileges are very wide and all encompassing, which means that anything and everything said by a parliamentarian in the parliament comes under parliamentary privilege, and the parliament and that parliamentarian would be free from facing any action over that. Max to max, his or her remarks might be expunged from the proceedings of the parliament. However, it is free from any criminal action being taken against him, purely because like he enjoys exclusive rights of parliamentary privileges. Now, coming to your question on sedition, if you know, there is a difference, and you have rightly pointed out that there's a difference between the government and the ruling party constituting the government. And this is let me tell you, sedition is basically targeting the government. You are inciting feelings of hatred against the government and not as such against the ruling party. So there is a difference. For instance, if let's say person A makes a remark against the MLA of a ruling party, that would not amount to sedition. However, if that person, same person, makes a remark stating, okay, the government of India has done so and so, it is violating the rights or whatever, that amounts to sedition. That would fall under sedition. I hope I made myself clear pertaining to the point that you raised, or do you have any more clarifications to seek?
No, ma'am. Thank you.
Okay, okay. So after this, since we have anyways, I'm exceeded my time. Pranav, do I have 5 more minutes to quickly touch upon the freedom of assembly and association?
Yes, yes, you have. Please
Okay,
take your
okay.
time.
Thank you, thank you. So, if you look at Article 19(1)(b) and Article 19(3), they talk about freedom to assemble as well as the restrictions pertaining to free assembly. So, 19(1)(b) says all citizens shall have the right to assemble peacefully and without arms. However, as per 19(3), nothing in subclause B of the said clause shall affect the operation of the existing law insofar as it imposes or prevents the state from making any law imposing, in the interest of the sovereignty and integrity of India or public order, reasonable restrictions on the exercise of the right conferred by the said clause. If you look at the restrictions which are given under clauses, subclauses 2, 3, and 4, I want you to notice that the restrictions differ with respect to the importance of that particular right. So, for instance, freedom of speech and expression is an important right, and its misuse also equally has important ramifications pertaining to the harm it can cause, and which is why the number of restrictions mentioned under subclause 2 are way more well defined as pertaining to, let's say, the restrictions under clause 3. So if you look at it, uh, there has not been a lot of contentions or issues pertaining to the right to form associations or unions. So we will quickly move to pertaining to assemble peacefully and without arms. So now we will quickly move to Article 19, subclause 1, Part C, which is right to form associations or unions. I have one statement to make. I want any of you to explain that to me, which is that article, the right to form association is the very lifeblood of democracy. Can you please justify this? I mean, I want first of all you to express if you agree with this or you don't agree with this, and if you agree with this, I want you to justify this. Anyone? Okay, we also have a few questions. Can you guys wait till I get to complete this, and we can then take all of the questions at once? Does this work? So that I get to quickly finish this off. Asifa,
Yes.
Anas. Yeah. Okay. So my turn first. First, you answer my question, and then I'll answer yours. So I say that right to form association is the very lifeblood of democracy. Uh, do you want to share your thoughts on this?
Yes, ma'am.
Yeah, yes, yes.
The more institutions and associations will form, that leads to checks and balances of the government.
Very right, very right. So, see, democracy ultimately means that you will have to have a lot of political parties being formed, because there has to be someone to counter what the government, any wrongful actions of the government. As you say, that dissent is good for democracy. However, in order for that dissent to be there, you need to have associations that can actually dissent with the government, and not just organizations that agree with, or work hand in hand with the government, because it's important. Government are, after all, humans, and they can always make mistakes. So it's important to have organizations or parties to counter the wrongful acts of the government, and which is why this right to form association allows individuals to come together to form political parties, and which is why it's called the lifeblood of democracy. So again, like, if you look at right to form associations, there's not much of a contention. However, there's one contentious issue, that just like freedom of speech has a concomitant right pertaining to not to speak, does right to form association also includes right not to form association? Now this becomes important. For instance, if you are working in an organization, and that organization asks you to be a part of whatever association that it has, asks, it expects you to regularly attend the meetings of that association and contribute. However, you might not be very willing to be a part of that association, and you not attending that association might also have disciplinary proceedings against yourself. So in that scenario, it becomes important to understand that does right to form association also include right not to form association? Do you want to share your views? What do you think? Should it be a part of it, or it should not be a part of this? I promise this is the last question from my end. I will end my session with this, and then the floor would be open for questions and discussion. Anyone? Yeah.
Yes, ma'am. May I?
Yeah. Yes, Benita, please.
Ma'am, right to not to form association should also be a part of right to form association, as because every individual has right to choice what we say. So again, it falls under our right to personal liberty as to whether we want to be a part of it or not. So it should also be like considered. Choice of people should be considered when it comes to people asking them to be a part of certain thing, or whether they shouldn't be a part of certain association.
You are very right, Benita, and you have a very logical response, justification for your opinion. And however, you'll be surprised to know that the Supreme Court has a contrary stand on this. The Supreme Court in Tika Ramji versus State of Uttar Pradesh, which is a case of, though it's an old judgment of 1956, the court said that just because we have a right to association does not mean that you have a negative right of not to form association. However, there are a few high court judgments wherein the high courts have observed that right to form association should be a part of sorry, right not to form association should be a part of right to form association, based on the logic which Benita gave. However, this matter still remains unresolved, since there have been what do I say, opposing judgments, and with the Supreme Court in 1956 saying that it is not included. So with this, I would want to conclude, since I've already exceeded my time that was given to me. I am really thankful to Pranav for being so generous with the time, and to all of you for your patient listening. Now, I will leave the floor open for questions or any inputs that you all might want to add to what the discussion was all about.
Thank you so much, Dakshita. I think that this has been one of those informative sessions which LRA is always seeking for. So, before the question comes in, I would like to really thank you on behalf of Legal Research and Analysis, that you have done a very nice, maybe, job to give a conceptual clarity about it, because most of the our interns are students of law, and they might have gone through it, but the way you have cleared the concept is something very commendable. So thanks on our behalf. And now I think that there are lot number of questions which are waiting for us. questions which are going to come in, because the more you explain, the more clarity comes and the more questions pop in, which makes which is very clear in our window also. So maybe now we can open the floor for discussions. And it's just a genuine request from everyone that whoever is asking the question, kindly keep it crisp and short and come to the point, so that we can entertain all the questions which are coming in the loop. I hope that works. With
Yeah,
this,
and
yeah.
Pranav,
Yes,
since
Deepika.
you yourself have been a student of law, I would really request you also to give your insights to the questions that are being asked. Yeah.
I'll make sure I'll also try to help
Okay.
you
All
all.
right.
Yeah.
Yeah. So
Okay.
I think Asifa has raised her hand, and Vatsalya.
Hello.
Yeah. Hi. Hi, Asifa.
Hello, ma'am. One thing I want to ask is because I am from Pakistan, and when you say about the traveling, you discuss about any case law in which the lady wants to travel abroad, and there was some restriction, and the court allowed her to travel back to share her to secure her right of expression. On this point, I have a question is because you know all the conflicts and everything beyond the borders, but when we have our ancestors in India, when we apply for that, we always got restriction for that purpose. Isn't it violation of human rights of the expression which you discussed?
It is, Asifa, but if I can just quickly answer your question in one line, is that rights given under Article 19 are restricted to the citizens of India. And I think the cases which you are mentioning pertain to people who might not be citizens of India. So the question of violation of that right cannot arise in the very first place. Uh,
Okay, I want to ask on a broader perspective, not particularly to the in India. Uh,
okay.
that's why I put my question there. Like, if we see in international forum, international rights, we have many rights to travel at any place without any restrictions. But when it comes to India and Pakistan relation, we have always some conflicts between that. Particular case, but since some of my ancestors were from India and they live for a long time period, we have our traditions and cultures over there. But if we want to travel there, we are always being restricted, for the particular purpose. I know it's something different, but if we talk about the violation of the rights, then it is the basic violation of the right that we are being restricted for to travel to India, basically.
Right. See, you have a very important point that you have raised there when you say, but I want to highlight a few points, particular to the context that you have given to all of us. When you come to India and Pakistan, you know, historically we have had very troubled relationships, and I think somewhere when the constitution was being drafted, the memory of communal violence of partition was very much fresh in the minds of the ancestors, and which is why I think this was one of the reasons. If you look at the constitutional assembly debates which are freely available online pertaining to the framing of the constitution of India, there have been apprehensions in the minds of the framers of the constitution pertaining to the misuse of the rights which are being given under article, the freedoms which are being given under article 19, and which is why it was considered important to impose restrictions pertaining to the sovereignty and integrity of India. And which is why, if you look at it, most of the objections that might be raised by the government of India in restricting the movement of people from India or outside India will pertain to the sovereignty and integrity of India. And very, if I be very specific to the context of the question which you have asked, the answer is very simple. These rights are restricted. The enjoyment of these rights is restricted to the citizens of India, and there is a purpose behind this. And which is why, so for instance, when one Indian citizen, Menka Gandhi, was stopped from leaving the country, the court did discuss the violation of right under article 19(1)(a), even though there was a discussion on article 21, but the court did say that it is violating her right under 19(1)(a). The situation would be completely different if the right of a non-citizen in a similar fashion is being violated by the government of India, because government has all the right, and that person will not be will not have any redressal to his to his end, because very simply article 19 does is restricted to be enjoyed by the citizens of the country. And you are absolutely right when you say that it, on a very fundamental level, it is a basic violation of the human rights if you look at international the covenants pertaining to civil and political rights. However, the question then that comes up pertains to the applicability and enforceability of international conventions in the Indian context. Not all international conventions are per se applicable in India, even though India is a signatory. But any laws, if India has made similar laws, the laws of the national laws will always pertain. And this has something to do with the enforceability of international law as such. Like I do not have that much time to go into the philosophy of enforceability of international law, but I'm sure as students of international law, we would have read that this is one very big issue, in fact, which is why international law is not called a law at all by many scholars of international law, because it lacks enforceability. So I hope I was briefly able to touch upon the issue that you have raised.
Thank you so much,
Yeah, I
ma'am. Thank you
think
so
I
much.
think
It's
it was a very
perfect.
nice way to explain.
Okay, okay,
Yeah.
thank you.
Thank you, Dakshita.
Yeah. uh, okay, so we had someone else also raising their hands. Yes,
I
Sheikh.
would just like to request that who is writing down in the comment box may, if possible, ask the questions, because we are open to hear you.
Yeah,
So,
thank you. Yeah, thank you for giving me this opportunity. I would
Yes.
like to understand the gray areas of our the Indian constitution regarding something like, for example, Assam. Like we have the foreigners tribunal in Assam, which go beyond Indian constitutional legality, and there the foreigners tribunal that applies there, they do not come from, or they are not created from the constitution, or they do not have any constitutional validity as far as Indian citizens are concerned. So this is a one gray area. Another gray area is the Indo Nepal Treaty of 1950, where Nepalis who are born in Nepal, they obviously cannot vote in India, but they do have certain rights, extra rights, which Pakistanis and Bangladeshis and Sri Lankans do not have. And I would also like to understand how does Indian people get disqualified as a doubtful voter in Assam, and why do like their legal redressal mechanisms or such things are not being thought over by mainland Indians, and what are lawyers trying to do regarding all these gray issues as far as Indian constitution goes. Thank you.
Okay, okay, Sheikh. Thank you for bringing this up. Now, the issue that you have raised pertains to the applicability of general law vis-a-vis specific laws. Now, there's a rule of interpretation which says that if there is a specific law in contention with a general law, that specific law will prevail. Now, the instances which you have cited pertain to, now see, understand, Constitution of India is an all encompassing law. It's a general law which is applicable uniformly across India. But if there is a specific law to deal with a specific scenario, that law will mostly be prevailing over any general law. It has to conform to the general philosophical underpinnings of the Constitution. However, when there's a conflict, that specific law will prevail. Coming to the Indo-Nepal treaty that you talk about, and you say that Nepali citizens do have certain rights in India as against citizens of other neighboring countries. This is an area of foreign policy wherein the government of India is free to enter into understandings or agreements with any state it wants. It's a sovereign country. It has all the right to enter into an agreement with any country and give whatever rights or enjoy whatever right it wants to. We cannot say that, okay, there's this understanding with Nepal, then just because India entered into an agreement with Nepal, it should also enter into an agreement with all other countries. This is like, there are so many concepts. The global politics work on this. There are so many concepts. For instance, the most preferred nation. Now, if you look at it, Pakistan might have given the most preferred nation status to various other countries. However, that the same is being denied to India. Now, we cannot say, okay, just because the government of Pakistan has given the most favored nation status to one country, every other country should be given, because that would somewhere negatively impact the sovereignty of Pakistan. And this is one very important principle of international law, that all states are equally sovereign. So. As I said, and even if you look at the specific laws, for instance, someone mentioned about the UAPA, or if you're saying the Foreigners Tribunal, all of these laws are being justified on the grounds that because certain rights are being restricted using these laws, it's because they are important to maintain the sovereignty and integrity of the country. However, since you asked if lawyers are doing something about it, so yes, there are a lot of lawyers who are working pro bono, and they are extending their services for and they're fighting for the protection of human rights of citizens in these disturbed areas. And there's always this friction that is ongoing in the courts between the human rights activists and the government with respect to the violation of rights, as against protection of sovereignty of the country. So yes, there are being efforts that are being made on this ground.
But ma'am,
Yeah,
UAPA, if I am being tried under UAPA, it is ultimately Indian courts,
yeah,
which
yeah.
is going to give me clean chit or going to put me further problems on my movement. But as far as Foreigners Tribunal goes, Foreigners Tribunal fall beyond Indian constitutional capacity. And we actually, Indian constitution does not work in Foreigners Tribunal. And at the same time, like we don't have any legal mechanism,
Hmm.
even from an international point of view, to deal with Indians who have been, because of political reasons, have been rendered disqualified voter. And even this disqualified voter process, how to determine someone has to be disqualified, this is also very arbitrary. And in like at times I feel like Assam scenario and Assam state is much more bigger than India, because whatever CA we see, whatever we are seeing from 1983 onwards, it is Assam Accord which is dictating citizenship laws in India. So somewhere down the line, I as a Indian taxpayer living in West Bengal, I just feel ki Assam is bigger than India. Like this
Okay,
sentiment, from
okay,
a layman's point of view, I just want to
okay,
understand
okay.
the
Uh,
legal reasons for these kind of things.
right. So I'm very.
Dakshita, before you answer, Dakshita, I just want to like maybe ask one thing, Sheikh. That I understand your contentions regarding that, but then I beg your pardon to state that actually we are more of discussing about the fundamental rights in this particular context. We understand that the gray areas are more and the concerns are also more. But then, I'm sorry to cut you in the middle, but then if you keep on discussing about this concerned issue, I think this requires another session for that matter. So maybe there are other questions in the loop. I would like just, I might be disrespecting your question, but then just to get an analysis of it, I think Dakshita has made her point very clear that there are some things which are not in loop, and you have to actually keep track of it and then find an analysis to it. I think Dakshita will then give a final conclusion to it, because we have other questions also in the loop. Since I'm the moderator, I have to keep the track of the other concerns also. I hope that works for you, sake.
But just one point to add to what Sheikh said pertaining to the. I'm sorry, Pranav. Can I do that? I mean,
Yeah,
I just
please,
have
please,
one
please, please.
point for
It was
Sheikh,
just for
because
you. Yeah. Okay. Yeah.
first of all, Sheikh, the laws that you have cited pertain to the citizenship. However, if you look at it, the Constitution of India does not prescribe any laws, any provisions pertaining to the citizenship of the of the Indians as of today. if you look at part 2, which is article 5 to 11, they talk about the citizenship at the time the constitution was being framed, and it was very clearly mentioned in that part that for the citizenship, for determining the citizenship afterwards, the government has to come up with specific laws, and which is what the government has done when it has made laws pertaining to the determination of citizenship of, let's say, for people staying in Assam or any other part of the country. Okay, yeah. So we have Raju Kumar. Raju, would you like to unmute?
यस मैम।
Yeah.
यस मैम। मैम मेरा क्वेश्चन ये है कि जैसे कि आसिफा ने बताया कि जब भी ये बात आती है पाकिस्तान सिटीजन्स को इंडिया में आने की, तो उन्हें रोक दिया जाता है। तो मैम अकॉर्डिंग टू यूडीएचआर आर्टिकल 13 राइट टू फ्रीडम जो डिस्कस किया गया है मैम उसमें, तो उसमें ये बोला गया कि मैम कि एवरीवन हैज़ द राइट टू लीव देयर कंट्री एंड सेटल अदर कंट्री। सो मैम मैं आपका इसमें आपका पॉइंट ऑफ व्यू जानना चाहूँगा कि इन इंटरनेशनल लेवल पे जो
Ma'am, can I answer
पाकि
this question?
Yeah, sure. But
Ma'am,
Raju,
he's
would you
talking.
want to just a minute, Sakshi? Raju, would you want to complete your question? I
यस
think you
मैम।
were saying something. Yeah, please.
यस मैम। तो मैम इन इंटरनेशनल लेवल पे जैसे यूडीएचआर का वायलेशन हो रहा है यहाँ पे, पाकिस्तान फॉलो नहीं करती इस चीज़ को अगर हम देखें तो मैम आपको नहीं लगता है कि जितने भी सिग्नेटरी स्टेट्स हैं इनके अंदर यूडीएचआर के अंदर, उनको कोई स्टेप लेना चाहिए इसके रिगार्डिंग? और मैं इसमें प्रणव सर का भी थोड़ा ओपिनियन जानना चाहूँगा।
Okay, Sakshi, would you want to respond? And then
Yes,
obviously
ma'am,
we'll
he's
share our
talking about the right to movement from one country to another. So basically, अगर आप किसी जैसे कि आप किसी भी कंट्री में शरण लेते हैं तो उसके लिए कुछ मतलब रीजंस होते हैं, जैसे कि मान लीजिए वहाँ पे कोई वॉर चल रही है तो उसके कारण उनके ह्यूमन राइट्स या फिर उनके राइट्स को दबाया जा रहा है, तो तभी आप दूसरी कंट्री में आके मतलब वहाँ पे शरण ले सकते हैं। और जब मतलब वहाँ पे सेटल हो जाता है या फिर उन्होंने उसको वहाँ से निकाल दिया है, तो जैसे दलाई लामा, द सिचुएशन ऑफ दलाई लामा इज द सेम रिगार्डिंग दैट पर्टिकुलर article of UDHR. So I think so that's
Okay, Pranav, would you want to go first?
Maybe after you. I would like to conclude
Okay.
that. Yeah.
So Raju, if I correct me if I'm wrong, but what आप जो पूछना चाह रहे थे वो ये था, your issue pertains to the applicability of or the enforceability of rights given under international conventions in India or in any other state, and that you gave one suggestion that states should come together and come up with a mechanism to ensure that international conventions are being enforced. Correct me if I'm wrong. Is
यस
this
मैम।
what? Yeah. So let me answer this, Raju. You need to understand international law is a complex web. As I said, since the beginning of the times of Bentham and all, there has always been this discussion pertaining to the enforceability of international law. You need to understand international law per se, because there is no mechanism at an international level which is potent enough to enforce the various rights given under the convention. It can only be done at the state level, wherein every state signifies, first of all, every state assents that international law accepts the particular convention, and then there are different mechanisms. For instance, if we talk about India, because this discussion was about India has to come up with a law adhering to the international law. Only then it can be effectively, I'm using the word effectively, it's enforceable even though there is no law made in India. But in order to it to be effective, India has to come up with a law to implement the provisions of international laws. For instance, one very good example of this is the laws pertaining to environmental law. I'm sorry, I'm transgressing into environmental law, but you need to understand, when Indira Gandhi attended the 1972 convention, she accepted the convention then and there. However, she came back to India and she had to come up with the Air Act, the Water Act, the Environmental Protection Act, and the Wildlife Protection Act. By doing so, what was she doing? The government at that time was accepting the rights or whatever the legal provisions in the international convention into the Indian scenario. So this is the only way, by which you can ensure enforceability. Otherwise, looking at the global politics, and you look at it, it's really messed up if we talk about global politics today. But it's very difficult. It's easier said than done. It's very difficult to come up with a mechanism internationally whereby you can enforce, per se enforce the rights given under international conventions. So I hope.
Yeah, I
Yes,
think that you have fairly justified. In fact, I was also about to say the same thing. So when you're talking about the UDHR, and then you may talk about the ICCPR or ICESCR. These are the conventions that came in the loop, right? So there are n
yes,
number of basic human rights which has been enshrined in these conventions. But then when you come to the applicability of the same, as far as India is concerned, then always international law is graded as a weak law, right? The domestic law is prevailed over the international law. So there is always a question of the how implementable it is, right? For that matter, I think that you have a very genuine question to ask, but then to answer to it, we don't have any straight jacket formula that why it is not happening, right? Because that in the back in the mind, you also know that things are not as simple as it is on the face of it, right? On the
yes,
record of it. I think that
yes,
makes a that maybe settle. You may settle down with this particular answer. With this, I would like
yes,
to
sir.
ask
Now
any.
it's clear, sir.
Yeah. Great.
Thank you, sir. Thank you, ma'am.
Oh, yeah, Upashna, would you please come with your questions quickly?
Yes. Ma'am, you are talking about freedom of speech. While you are talking about freedom of speech and expression, you also include freedom of press, right, ma'am? Press, ma'am, press. Yeah. Ma'am, you are on mute. I'm sorry, but you're on mute.
Ha, freedom
Yeah.
of press, yes.
Yes, but ma'am, nowadays, as we can see that the news channels are wearing a like a political color, and they are not giving their neutral view about any news or about any incident. So, ma'am, is there if there is no any obligation that they are misusing their power, and we can't do anything, like they're misleading the people, they're misleading everyone. So what's your opinion about this? Is there is no any obligations or anything on
See,
this?
Upasna, thank you very much. You've raised a very important question and a point there when you say that the press, when you talk about freedom of press, but unfortunately, press is not free anymore. There's very important exercise that has been conducted. If you look at the ownership of the most of the important press houses, you will realize these press houses are actually being owned by the most of the industrialists. For instance, I was recently reading this news piece wherein Adani has acquired rights in one very prominent press organization. I'm forgetting the name. Is it NDTV or something else? So this definitely shows that the press is not free anymore, that the press is being used to further the agenda of the party which is controlling it from behind. And this is in fact one of the very important concerns of our times when it comes to when it comes to talk about freedoms, because press, as I had mentioned earlier, is the fourth pillar of the government. It is supposed to support the government as well as put a check on the government, by raising awareness among citizens. However, when it starts to act on the whims and fancies of big industrialists, or for that matter even the state, it is somewhere endangering the rights of individuals. But this is where realism comes into play, and we need to figure out that how we as citizens can ensure that press is returned to its days of responsible reporting, wherein it's not furthering any propaganda or agenda, and rather it is doing the role it was supposed to do, which is ensuring awareness and literacy about rights to everyone and putting a check on the government.
Yes, ma'am.
I think you have very nicely and fairly justified. I think that a very nice point made by, I think the interns are also congratulating and they have understood it. I think that there are n number of questions maybe in the loop. So I would beg pardon from all of you that we'll have to end up this session. It's very inspiring that you keep on asking questions only when you actually understand the query for that matter. So I think that we may congratulate Dakshita for that. That she has made such a clarity in the mind of the people that they keep on asking for that. So I'm sorry for those who are right now asking or maybe trying to ask the questions, because we have exceeded our time limit, and I believe that we had taken her or maybe asked her or requested her to give her 30 minutes, but she has extended her 1.5 hours. So I think this is a thing which we can always be thankful to her. I think that those questions which are coming, maybe noted it down. Ryan, could you please note down all the questions? You can maybe keep it on the comment, and then, if possible, we will forward it to Dakshita, and she'll maybe take your queries later. Will that work with
Sure,
you,
sir.
Dakshita?
Yeah, I will be more than, and as you said, Pranav, this has nothing to do with me. In fact, I am very delighted to know that, this is such an informed group of interns today that I got to interact with, and the kind of questions that were coming up, it shows that, people are actually and truly concerned about rights. And I got to learn so much. I'm not sure how much I could contribute to the session, but I definitely got so much to learn from you all. And yeah, I would be very much happy to answer your questions in writing later on, since like we are not left with any more time. So yeah.
Right. I'm really sorry for those who couldn't maybe make out or maybe whose questions could not be addressed. But then we make sure that your questions will be addressed. If not now, then maybe as soon as possible by her. Right. With this, I would like to give a vote of thanks to Dakshita, that she has been phenomenal throughout. The way she came, she took it on her own, and when I very much feel that any of you would connect the same, that how good she is with her conceptual clarity. I think that the interns will be willing to maybe call her again if possible, if she can give her precious time. If anybody of you, like just Binita or anybody, could give a feedback of how ma'am's maybe concept was on freedom of speech and expression and other perspective. Any one of you, please. How would you? Yeah, Binita.
Yes, sure. Like, whatever concept we had with regard to right to freedom of speech and expression, ma'am made it more clear. Like, we could get the we could get concept in depth, and like also contribution, like what, much more to add in our knowledge. So, thank you so much, ma'am, for your lovely time.
Yeah, thank you, Binita. With this, I would ask Dakshita to take the leave, and maybe then we can resume in our further sessions, which are going to come in the loop. With this, thank you, Dakshita, and thank you everyone to join this session. And I hope it has been an informative session. Rayan, you can
Hello,
take the lead and
brother.
close the session.
Yeah. We have few announcements before we
Okay.
Yeah,
leave.
please.
Uh,
Yeah,
uh,
meanwhile, we can ask Dakshita to maybe take her call, and maybe she can leave
Okay.
this
Okay.
particular
Yeah.
session.
Yeah.
yeah,
Thank
yeah,
you.
she
Just
can.
to like end it, thank you once again for having me here. It was like really great. It was very informative. Thank you, Pranav. I'll take your leave now. Good
Yeah,
evening.
thank you. Thank you
Yeah.
so much. Yeah, okay. Yes, Rian, now you
Okay.
can make the announcement.
Yeah, we have few articles to give the appreciation. I have noted out a few contents. Just I have mentioned earlier that we will mention three articles, the best article of the first assignment given to the interns. But I can't stop myself announcing few more as they were very beautifully written. Uh, just before announcing, I want to make sure that the name and the title I'm going to announce is beside the content. The content of every intern was very good and very concise and great, pertaining the every meaning of the that content. But as of we are also going through the rules and requirements of the article writing, and we also the requirements of SEO. So I've just pointed out few out of them. So on the first we have violations or the right to vote in Nigeria by Hanatu Jiga. uh, Hanatu, very well written. And the next we have an article by Irshad Ali, the stigma around the reproductive health of women and the way forward. So very well written, Irshad. We just need to make more things, acknowledge that we must use headings and subheadings and H headings H1 and 2, 3, which we have taught you in the session 2. And up to next, we have uh, Rupesh Rupesh with an title Early Marriages Child in West Bengal and Bihar. And the next one is by Shriya Oja, the Pegasus and the predicament of the privacy. The next we have by Bhushan Tripathi, death penalty of cybercrime and with case law references. And the last from Miss Tanvi Jindal, Afghanistan Women's Fight for Rights. So very well written, all of these, and we appreciate your content. And Fazal, you have raised hand. If you want to ask anything, please go ahead.
Congratulations to everyone.
Fazal. Okay. So very good work, and I appreciate everyone who submitted the assignment. And for the next, I will announce the next assignment by tomorrow evening. So anyone want to ask anything regarding the program or any other question, you may go ahead, please. No questions. Okay, I think we are done. We may have leave. So if you guys have any question, you can ask me anytime, as you all of know.
Thank you, Rehan, for conducting such a good session. I think that we all have exhausted this particular time, and in the next session, we are going to have something else coming up in the loop. With this, I would like to take your leave, and maybe others can also take similarly. Thank you, everyone, for joining.
Thank you.
Thank you, sir.
Thank you, sir.